It seems the gun-grabbing state legislators and governors had no idea what they were in for with the New York State Rifle and Pistol versus Bruen case. They poked the Second Amendment bear one too many times, and it seems to have backfired on them. Because of Justice Thomas's carefully and strategically written decision, current and future gun laws will likely be scrutinized and required to meet historical precedent. At a certain point during the anticipation of the Supreme Court New York State Rifle Pistol Association versus Bruen decision, it started to become clear that the case would be decided in favor of gun rights. What was unclear was the way the decision would be written. State legislators had a lot of leeway after the Heller and McDonald cases, and they used every bit of leverage they had to continue violating the rights of American gun owners despite those two favorable rulings. All that has changed because Justice Clarence Thomas had some very interesting wording in his Bruen decision. Besides the text that referred to the right to carry a gun not depending on service in the militia, and the portion that stated, "We conclude that respondents have failed to meet their burden to identify an American tradition justifying New York's proper cause requirement," the decision was written in a way that now requires all gun laws to meet a level of historic balance. It appears that anti-gun lawmakers will now have a much more difficult time restricting the rights of the people they represent. The provision to meet historical precedents reads as follows. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with this nation's historical tradition of firearm regulation. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Attorney and Rhode Island Democrat State Representative Robert Craven said he would study the New York case to determine whether Rhode Island's requirements could be challenged and whether that can be remedied by legislation. He questioned whether the High Court will now employ a strict interpretation of the Second Amendment, that the right to bear arms is absolute, and apply it to other laws, such as those banning military-style weapons. He said, "I see the court headed in that direction." On June 27, 2022, it was reported that attorney Chuck Michel, who heads up the California Rifle and Pistol Association, said the standard will affect three prominent California laws in particular. These cases are pending before a federal appellate court. Legal challenges to the state's limit on assault weapons, requirement for background checks for buying ammunition, and a ban on online ammunition sales. On June 28, 2022, the district court's judgment on California's so-called assault weapons ban has been vacated, and the case was remanded to the district court for further proceedings consistent with the new Bruen decision. On June 29, 2022, Bianchi versus Frosch, Maryland assault weapons case, has been vacated and sent back to the Fourth Circuit Court. New Jersey's large capacity magazine case has been vacated and sent back to New Jersey for further consideration. California's large capacity magazine case has been vacated and sent back to the Ninth Circuit. Young versus Hawaii open carry ban has been vacated and sent back to the Ninth Circuit for further consideration. So despite the narrative by which they're sold to the public, California gun laws have been notorious for restricting the rights of law-abiding Californians while doing nothing to reduce violent crime. This new Supreme Court decision has put California gun laws in question. It's caused New Jersey governor to reverse course on his draconian gun measures and has worked New York Democrats into a lather as they desperately search for new ways to control the rights of New Yorkers. We're in a very important time, and it looks like there's a good opportunity to drag the Democrats back to civics class and force them to reread the Constitution with special focus on Amendment number 2. The Bruen case may change everything when it comes down to gun laws in America. I'm Dan Wass, and this has been another AmmoLand News Second Amendment Update. Tell us what you think in the comments below and share this with your family and friends to help support AmmoLand News, America's oldest Second Amendment news outlet.